The non-aggression principle is an ethical and moral principle that aims to avoid conflict between individuals by prohibiting crimes like theft and murder. The crimes prohibited by the NAP are behaviors that are malamenche as opposed to behaviors that are prohibited due to laws, social norms, or moral systems. The principle asserts aggression is always an illegitimate encroachment upon another individual's life, liberty, or property, or attempt to obtain from another via deceit what could not be consensually obtained. For example, the NAP prohibits the initiation of force by one individual or group of individuals against another individual or group of individuals. The NAP is the defining principle of libertarianism. According to some libertarians, the NAP and property rights are closely linked, since what aggression is depends on what a person's rights are. Aggression, for the purposes of NAP, is defined as initiating or threatening the use of violence against an individual or legitimately owned property of another. Justifications. The principle has been derived by various philosophical approaches, including argumentation ethics. Some modern libertarian thinkers ground the non-aggression principle by an appeal to the necessary praxeological presuppositions of any ethical discourse, an argument pioneered by libertarian scholar Hans Hermann Hoppe. They claim that the act of arguing for the initiation of aggression, as defined by the non-aggression principle, is contradictory. Among these are Stephen Kinsella and Murray Rothbard. Consequentialism. Some advocates base the non-aggression principle on rule utilitarianism or rule egoism. These approaches hold that though violations of the non-aggression principle cannot be claimed to be objectively immoral, adherence to it almost always leads to the best possible results, and so it should be accepted as a moral rule. These scholars include David Friedman, Ludwig von Mises, and Friedrich Hayek. Christian worldview. There is an emerging biblical argument that the natural rights of Locke, Rothbard and others are most truly derived from the biblical principles of self-stewardship and the image of God in man. The rights to life, liberty and property derive from the fact that God has granted each person to be the steward of himself and none other, granting him the human authority to manage his own life and property, which morally requires him to do so according to God's law, but civilly requires him to respect the dignity and property rights of his neighbor. The biblical purpose of civil government is to serve on behalf of individuals who have had their life, liberty, or property violated by another. Natural rights. Some derive the non-aggression principle deontologically by appealing to rights that are independent of civil or social convention. Such approaches often reference self-ownership, ethical intuitionism, or the right to life. Thinkers in the natural law tradition include John Locke, Lysander Spooner, Murray Rothbard, and Robert Nozick. Objectivism. Ayn Rand rejected natural or inborn rights theories as well supernatural claims and instead proposed a philosophy based on observable reality along with a corresponding ethics based on the factual requirements of human life in a social context. She stressed that the political principle of non-aggression is not a primary and that it only has validity as a consequence of a more fundamental philosophy. For this reason, many of her conclusions differ from others who hold the NAP as an axiom or arrived at it differently. She proposed that man survives by identifying and using concepts in his rational mind since no sensations, percepts, urges or instincts can do it, only a mind can. She wrote, since reason is man's basic means of survival, that which is proper to the life of a rational being is the good, that which negates, opposes or destroys it, i.e., initiatory force or fraud, is the evil. Estoppel. Stephen Kinsella believes that the legal concept of estoppel implies and justifies the non-aggression principle. Definitional issues. Abortion. Many supporters and opponents of abortion rights justify their position on NAP grounds. One important question to determine whether or not abortion is consistent with NAP is at what stage of development a fertilized human egg cell can be considered a human being with the status and rights attributed to personhood. Some supporters of NAP argue this occurs at the moment of conception. Others argue that since the fetus lacks sentience until a certain stage of development, it does not qualify as a human being, and as such may be considered property of the mother. Opponents of abortion, on the other hand, state sentience is not a qualifying factor. They refer to the animal rights discussion and point out the argument from marginal cases that concludes NAP also applies to non-sentient humans. Another important question is whether an unwelcome fetus should be considered to be an unauthorized trespasser in its mother's body. The non-aggression principle does not protect trespassers from the owners of the property on which they are trespassing. It can also be argued that unwelcome fetuses are themselves committing aggression against their mothers by taking materials from her bloodstream, by injecting toxic metabolic end products into her bloodstream, and by preparing to subject her to major medical, surgical trauma in the form of full-term labor and delivery. Objectivist philosopher Leonard Peikoff has argued that a fetus has no right to life inside the womb because it is a parasite. Pro-choice libertarian Murray Rothbard held the same stance, maintaining that abortion is justified at any time during pregnancy if the fetus is no longer welcome inside its mother. Likewise, other pro-choice supporters base their argument on criminal trespass. In that case, they claim, NAP is not violated when the fetus is forcibly removed, with deadly force if need be, from the mother's body. Just as NAP is not violated when an owner removes from the owner's property an unwanted visitor who is not willing to leave voluntarily. Libertarian theorist Walter Block follows this line of argument but makes a distinction between evicting the fetus prematurely so that it dies and actively killing it. Pro-life libertarians, however, argue that because the parents were actively involved in giving life to another human being and the fetus was brought inside the mother's body, without his or her consent, the fetus is in the womb by necessity and no parasitism or trespassing is involved. They state that as the parents are responsible for the fetus apposition, NAP would be violated when the fetus is killed with abortive techniques. Intellectual property rights. NAP is defined as applicable to any unauthorized actions towards a person's physical property. Supporters of NAP disagree on whether it should apply to intellectual property as well. Those who don't think so claim IP can be copied by others without any harm to the originator. The argument reflects an analysis of the fundamental reason behind property rights: scarcity. Some claim ideas are not scarce because if A takes an idea of B, he does not prevent B from retaining the idea. Others state ideas are just as scarce as any other commodity since it requires time, money and labor to develop an original idea. If other people decide to use the idea, they also make unauthorized use of the effort of the originator, which would violate NAP. Likewise, not opening IP could be seen as harmful to society at large. Those who think that NAP should be applied to IP in the same way as to physical property argue that all IP is somehow sublimated in physical property, and that any owner has the right to determine what is done with his physical property. For example, if a software engineer writes a program on his own computer, a copy of this program can only be obtained by using the engineer's computer. If the engineer then burns his program onto a DVD-ROM and sells this DVD to a third party, he may sell this product unconditionally or, as would be normal in most cases, under specific conditions. In the latter case, unauthorized copying would violate NAP as the engineer co-owns the DVD and a third party cannot make a copy without using the engineer's property. Interventions. Though NAP is meant to guarantee an individual's sovereignty, libertarians greatly differ on the conditions under which NAP applies, especially unsolicited intervention by others, either to prevent society from being harmed by the individual's actions or to prevent an incompetent individual from being harmed by his or her own actions, is an important issue. The debate centers on topics like the age of consent for children, intervention counseling, involuntary commitment and involuntary treatment with regards to mental illness, medical assistance, human organ trade, state paternalism and foreign intervention by states. Other discussion topics on whether intervention is in line with NAP include nuclear weapons proliferation, and human trafficking and immigration. Non-humans supporters generally argue that NAP only applies to humans, because humans generally have a free will and a self-conscious and rational mind, as well as a moral understanding. Most humans can therefore understand NAP and can be held accountable for their actions. Some critics claim that although these abilities are common, they are not universal characteristics of the species. Young children and mentally handicapped persons may not have them. When NAP applies to them as well as to normal people, as supporters of NAP agree. Critics state that logically NAP should apply to all life forms with similar characteristics. This stance would lead to similar rights for sufficiently intelligent animals. Some libertarians justify the existence of a minimal state on the grounds that anarchism implies that the non-aggression principle is optional, because the enforcement of laws is open to competition. They claim competing law enforcement would always result in war and the rule of the most powerful. Anarcho-capitalists usually respond to this argument that this presumed outcome of coercive competition is not likely because of the very high cost, in lives and economically, of war. They claim that war drains those involved and leaves non-combatant parties as the most powerful, economically and militarily, ready to take over. Therefore, anarcho-capitalists claim that in practice, and in more advanced societies with large institutions that have a responsibility to protect their vested interests, disputes are most likely to be settled peacefully. Anarcho-capitalists also point out that a state monopoly of law enforcement does not necessarily make NAP present throughout society, as corruption and corporatism, as well as lobby group clientelism in democracies, favor only certain people or organizations. Anarcho-capitalists aligned with the Rothbardian philosophy generally contend that the state violates the non-aggression principle by its very nature, because, it is argued, governments necessarily use force against those who have not stolen private property, vandalized private property, assaulted anyone, or committed fraud. Taxation proponents of the NAP see taxes as a violation of NAP, while critics of the NAP argue that because of the free rider problem in case security is a public good, enough funds would not be obtainable by voluntary means to protect individuals from aggression of a greater severity. The latter therefore accept taxation, and consequently a breach of NAP with regard to any free riders, as long as no more is levied than is necessary to optimize protection of individuals against aggression. Geo-libertarians, who following the classical economists and Georgists adhere to the Locke and Labour theory of property, argue that land value taxation is fully compatible with the NAP. Anarcho-capitalists argue that the protection of individuals against aggression is self-sustaining like any other valuable service, and that it can be supplied without coercion by the free market much more effectively and efficiently than by a government monopoly. Their approach, based on proportionality and justice and damage compensation, argues that full restitution is compatible with both retributivism and a utilitarian degree of deterrence while consistently maintaining NAP in a society. They extend their argument to all public goods and services traditionally funded through taxation, like security offered by dikes. History. The principle was first formally enunciated by popular philosopher Ayn Rand. It was subsequently popularized by libertarians. Natural law theorist Murray Rothbard traces the non-aggression principle to natural law theorists Street, Thomas Aquinas and the early Thomist scholastics of the Salamanca school. This, in turn, may be seen in relation to Aquinas' view on greed, a sin against God, just as all mortal sins, inasmuch as man condemns things eternal for the sake of temporal things, and on envy, which be defined as sorrow for another's good. Proverbs chapter 3 verse 30 records it succinctly, "Strive not with a man without cause, if he have done thee no harm." Variations of it can be found in Taoism.